of this, if the Supreme Court of India feels that by overruling long-standing precedents, we need not hold a conference, then there is something wrong somewhere. What is backwardness? We want that twig of neem to be replaced by a plastic toothbrush and give them toothpaste packed in a plastic container. And that we call development. Defining scheduled caste, that is listing the scheduled caste. Only Parliament has the legislative competence to change that. And therefore, on this ground, she said that state legislatures can't do this. So, without a survey, without any study, if something is done, it becomes a problem. Those who are rulers, who ruled Maharashtra, are vying to be branded as backward. Why? Problem is no jobs, no work. That is a real issue. And then politicians play. They passed an act which got struck down in the Supreme Court. And now the entire state is on fire. I do not know how many of you have taken the trouble of reading 565 pages of the judgment of the Supreme Court. But I hope at least some of you would have taken this trouble of reading the judgment. The publicity in media has drawn a very skewed picture of the judgment. Today, in fact, there is a call for Bharat Bandh on account of that judgment. So, at least those who have read the judgment would know that it was not the Supreme Court of India which ordered sub-classification. It did not. Sub-classification had been legislated by assemblies of a few states. That legislation came to be challenged before respective high courts. And then the matter reached the Supreme Court. There was an earlier judgment of the Supreme Court, a 5-judge bench of the Supreme Court. So that judgment was authored by very erudite judges. But then, after that judgment came, which did not permit sub-classification. When this matter from Punjab came before the Supreme Court, a 3-judge bench of the Supreme Court felt that the matter was required to be deliberated upon by a larger bench. Because the earlier judgment, they felt that it was not a correct judgment. And this is how the Supreme Court of India on the 1st of August decided that sub-classification is permissible. Now, many of us feel that it is the Supreme Court of India which is trying to impose sub-classification as well as creamy layer concept. No. Creamy layer concept was already there as far as OBCs are concerned. While discussing the question of deprival of the backward amongst the backward, of the benefits of affirmative action, the Supreme Court felt that this benefit could be extended more effectively, efficiently, if creamy layer is excluded. Just as by deciding on sub-classification, what was felt by the legislatures, that some classes or some castes which had reaped the benefit of reservation to a larger extent could be excluded or could be reduced, not excluded, not excluded, but their preference, they should not be given a preferential treatment, or preference should be given to those who are more backward. So this was done by the legislatures. The Supreme Court, Justice B.R. Gavai, simply suggested, it is not a binding order of the Supreme Court that creamy layer concept should be implemented, etc. Supreme Court simply suggested that the Parliament may, in its own wisdom, consider whether this can be done or not. So I suppose the misconception about the judgment, that judgment tries to revolutionize something, is not correct. The well-meaning judges who had welfare of people who are deprived of benefits of reservations for a long time wanted to ensure that everybody gets the benefit, gets an opportunity of uplifting himself. And that is why, by upholding that judgment, upholding the laws about sub-classification, they felt that this could be extended to scheduled caste also, as had been done by the state legislatures. Again, I repeat, it was not done by any court. It was done by the legislatures. This was simply tested by the Supreme Court on the touchstones of, what are the touchstones on which Supreme Court tests law? First is breach of fundamental rights. Second is repugnancy. Third is the power to legislate. That is what they did. Okay. And therefore, let us understand the judgment from this context. But please do not understand me as suggesting that everything is fine with the judgment. There is a dissenting judgment by Justice Bega Trivedi. Now, just we'll try to see what Justice Bega Trivedi has said. Justice Trivedi had two objections. The first objection was that the reference itself was thoroughly unwarranted. There was no need for the three-judge bench to make a reference to the larger bench. Why did she say so? I think all of you have studied jurisprudence and law of precedent. No? Great. Okay. At least some of you have studied jurisprudence and law of precedent. What is a precedent? Judicial precedent, binding precedent. Judicial precedent is a decision by a court. It's not the decision, it's the reasons for the decision which bind. Okay. And the discipline requires, judicial discipline requires that judgment of a higher forum, a forum of higher strength, has to be followed by a forum, a bench of a lower strength. That is, a single judge has to obey, follow the precedent laid down by division bench. A division bench has to follow the precedent laid down by full bench, and so on. Now, this three-judge bench was bound to follow what the earlier larger bench had decided. It did not have that freedom to say that no, we disagree, and therefore let the matter go to higher forum. That was not correct. It could have said in its judgment that though we are of different view, we are bound by the decision of the five-judge bench, and therefore we hold accordingly. That three-judge bench had no business to criticize a five-judge bench. That is one objection of Justice Trivedi. The second objection which she raises is this. She says that this is against the legislative mandate. That is, state legislatures, because what has Supreme Court done is to accept the power of state legislatures to subclassify. She says this can't be done. Whenever a presidential notification is issued defining scheduled caste, that is listing the scheduled caste in the list, when they decide that these are the scheduled castes for various states, that can't be altered by anyone. Only Parliament has the legislative competence to change that. And therefore, on this ground, she said that state legislatures can't do this. Now, this submission was not dealt with in the majority judgments. I won't say submission, this observation of Justice Trivedi was not dealt with by the majority. There is only one word, please correct me if I am wrong, there is only one word in Chief Justice Chandrachud's judgment which sort of takes a snipe at the views of Justice Bega Trivedi. He has used the word conflict, C-O-N-F-L-A-T, and by describing, by branding something as conflated. He has deflated the point which was sought to be raised by Justice Trivedi. Now about this exhibits a disquiet. Did the judges of Supreme Court not get a time to sit together and discuss what were each other's views? Was a conference not necessary? This was an issue which went to the root of the matter. This was an issue which was very important for the national polity. But then I don't know whether a conference was held or not. This is not the first time possibly that the Supreme Court judges have failed to hold a conference. Long ago, there was a case, Union of India versus Tulsiram Patel. At least students of Constitutional Law must have read this case. This is about Article 311, Wager Doctrine. Now, this judgment was delivered on the last day of Justice D.Y. Chandrachud. No, D.Y. Chandrachud is yet to retire. On Justice Y.V. Chandrachud's retirement as Chief Justice. So, one of the members of that bench was Justice Thakkar. Now, this is what Justice Thakkar had said about this judgment. A benevolent and justice-oriented decision of a 3-judge bench of this court, rendered 10 years back in a group of service matters, Chagappan, is sought to be overruled by the judgment proposed to be delivered by my learned brother Madan, and with which the majority appears to agree. Chagappan having held the field for such a long time, it would have been appropriate if a meeting of judges constituting the bench had been convened to seriously deliberate and evolve a consensus as to whether or not to overrule it. That judgment, Chagappan had held the field for 10 years. It was sought to be overruled without a conference. A give and take of ideas with due respect to the holders of opposite point of view, in a true democratic spirit of tolerance, with willingness to accord due consideration to the same, would not have impaired the search for a true solution or hurt the cause of justice. The holders of rival viewpoints could have perhaps successfully persuaded and converted the holders of opposite point of view, got themselves persuaded and converted to other point of view. Brother Madan J, to whom the judgment was assigned by the learned Chief Justice, also appears to suffer a heartache on same score. In his covering letter dated 6th July 1985, forwarding the first installment of 142 pages, he says, I regret to state that the draft judgment could not be sent to you earlier, 142 pages. The reason was that as we did not have a meeting to discuss the matter, I did not know what would be the view of my other brothers, on the large number of points which fall to be determined in these cases. Except partly in the case of 2 of my brothers, with whom by chance I got an opportunity to discuss certain broad aspects. So 3 judges had met each other, discussed the points, but not all. Okay. So 3 got together and decided that others could be ignored. No. If only there had been a meeting in order to have a dialogue, there might have been a meeting of minds, etc. That was not to be. On the other hand, it has so transpired that the full draft judgment, running into 237 pages, has come to be circulated in the morning of July 11th, 1985, less than 3 hours before the deadline for pronouncing the judgment. 237 pages of a serious matter about overruling an earlier judgment to be considered, sent to the judges just 3 hours before the scheduled delivery. There is a time compulsion to pronounce the judgment, as on the 11th July 1985, the learned Chief Justice who has presided over the Constitution bench is to retire on that same day. So, without a conference, a judgment was delivered. And so Justice Thakkar wrote a note of dissent. Now this happened in 1985. In spite of this, if the Supreme Court of India feels that by overruling long-standing precedents, we need not hold a conference, then there is something wrong somewhere. Because ultimately what the bench writes becomes law for the whole of the land. There is another aspect. That is, how frequently should the Supreme Court be changing its opinion? If the Supreme Court itself is not sure of what law is, how you and I are going to know what is the law? How is the administration going to find out how it should organize its affairs, not knowing the law? My son happens to be a practicing advocate in Mumbai, and whenever a really difficult matter, which is in fact covered by a judgment of Supreme Court, comes to him, and the litigant says that, well, I have suffered injustice, and therefore something must be done in this matter. He does not say that no, your matter is covered by a Supreme Court judgment and therefore you can't get the relief. He says, well, there is a Supreme Court judgment which takes a view against what you are trying to get. But we will try. Because by the time the matter reaches the Supreme Court, the view might have changed. And if it does not change by that time, in your matter it may change. So speculation goes on. There is no certainty of law. The doctrine of precedent, the very foundation of doctrine of precedent is to have certainty of law. But if we go on changing with the change of the bench, what happens? You have heard, at least studied equity? Equity? No, or equity has been banned from the syllabus now. So there used to be a court of chancery in England, and equity jurisdiction was derisively described as chancellor's foot. That is, whatever chancellor decides becomes the law for equity, in equity. So let us not turn our constitutional law in chancellor's foot, that with every change of the bench, things changes. No, it can't happen. Yes, situation on ground did change. Some castes, among the scheduled castes, got the benefits of reservations and some did not. Agreed. But then this is for the legislature to consider, no? This has to be surveyed, decided. And it is for the legislature to decide as to how this bounty is to be distributed. I agree that our legislators or parliamentarians or politicians cannot be trusted to do this equitably, because they will have a view on the vote bank. Which community out of these, which castes have largest number of voters? Because ultimately it's a question of getting elected. But this was not the concern with the judiciary, no? So without a survey, without any study, if something is done, it becomes a problem. So the second count on which the judgment falters is breakdown of law of precedent. One researcher, Barry Walsh, I am happy that somebody is at least writing down the names. He may forget it afterwards, but do find out what Barry Walsh says about breakdown of law of precedent. He says that a large number of cases coming to the courts today are because of this breakdown of law of precedent. Either have this law of precedent, throw it away, no issue. Say that we don't follow the precedent. But we do follow the precedent from America. We do follow precedent from House of Lords, even now. We quote those judgments. then why not follow the precedent of our own court? And why disturbing it take time? Which was the first time that House of Lords overruled itself. House of Lords overruled itself for the first time after 50 years. That is, earlier judgment was given in around 1938 or something like that. And not 50 years, it was 20 years. After 20 years in 1958 or so, the judgment was overruled. Must have heard of Reverses versus Anderson. In Reverses versus Anderson, the question formulated was whether the Secretary of State has reason to begin. And the majority of lords held that when the Secretary of State states that he has reason to begin, it's enough. Lord Atkin, who wrote the dissent, please read that, that's very interesting. Because that is the first time that a piece of literature has crept into the judgment of House of Lords. He quoted from Alice in Wonderland, and he quoted a dialogue of Mad Hatter. Heard of Alice in Wonderland? You don't like literature? Please read it. It's interesting. In Alice in Wonderland, Mad Hatter says that when I use a word, the word must mean what I want it to mean. So Atkin said that I know of only one precedent for justifying what the majority is saying, that I mean something and that is good enough. So when Atkin wrote this dissent and quoted from Lewis Carroll's Alice in Wonderland, he was boycotted by other lords. They did not even have tea with him because he had ridiculed them. But then the majority was overruled. After 20 years, the House of Lords realized that no, Atkin was right and we were wrong. But this doesn't happen frequently. But the frequency with which we change the law, yet the law not become equal to Chancellor's foot, at least in constitutional jurisdiction. So this is the second objection. Third, about the legislative competence, I have already told you that this subject does not fall in the state list. And the article itself is very clear that any change will have to be made by Parliament. Even President does not have that authority. It has to be done only by the Parliament. But then it should have been left to the Parliament, no? No, the results which we can gather from Chief Justice Chandrachud's judgment is this. When he uses that word conflict, he says, possibly wants to suggest that there is a confusion in the earlier bench about the issue. We are not altering the list. The list of scheduled castes remains intact. We are not changing it. Or the state legislature is not changing it. What is it doing? It is doing some internal adjustment. Now, whether you call it an internal adjustment or a change, depends on how you look at it. Therefore, Justice Trivedi was of the opinion that this was beyond the legislative competence of the states. Now imagine today there is a big problem because all states, if they start doing all this, what will happen? Now there is a lot of migration. Many of you may be from outside Maharashtra. In your states there may be different lists, different scheduled castes, and then adjustment is done. How is this going to work in practice? Therefore, this aspect also should have been considered by the court. There is another judgment which is in fact concurring judgment, but I take it that the judge has expressed some different view. This is Justice Pankaj Mittal. he wrote a conquering judgment. He said, reservation is one of the modes of helping or uplifting the status of OBCs, SCs and STs. Anyone who suggests another or a better way of helping the so-called depressed classes or the downtrodden or the marginalized persons of the society is immediately pounced upon as anti-Dalit. Please read this sentence again from the judgment. At the cost of being called anti-Dalit, I quote Nani Palkhewala from his book Be the Nation, Lost Decades. The basic structure of constitution envisages a cohesive, unified class of society. By breathing new life into casteism, the judgment fractures the nation and disregards the basic structure of constitution. What did our founding fathers dream at? A casteless society. Not tukde gang. But what we are trying to do is have more fractions even amongst the scheduled castes. And this will spread to scheduled tribes also, no? In course of time. So Palkhewala says that the decision would revitalize casteism, cleave the nation into two, forward and backward, and open new vistas for internecine conflicts and vociferous forces, and make backwardness a vested interest. Has it become a vested interest or not? Has backwardness become a vested interest or not? Yes, it has. What does this Maratha agitation show us? Those who are rulers, who ruled Maharashtra, are vying to be branded as backward. Why? We go with superficial view of this problem. The problem is not this. Problem is no jobs, no work. That is a real issue. Why do Marathas fight? Because there are no jobs. There is no work. And then politicians play. They passed an act which got struck down in the Supreme Court. And now the entire state is on fire. Are we sometime going to address the issue of unemployment? Or are we going to leave it like that and fight with distribution of quotas here and there? It's a question of finding work for every hand. And what are we doing? Is there any work left in the farm? Any farmers here? Yes, there is a lot of work left in the farm. But youngsters don't want to do that farm work. Why? Weeding operations. Do you get labor for weeding operations? Do you get labor for harvesting? We use machines now. As far as industrial employment is concerned, it is already zero. One computer looks after 100 looms. The big industry in Bombay, textile big industry in Bombay, is killed. Have we stopped producing textiles? No. We get textiles, but where? Ichalkaranji, Bhiwandi, Magegaon, where one laborer, one person is forced to maintain 12, 13 looms and gets the same wage. We don't get laborers because we don't pay them a respectable wage. If we pay them respectable wage, you will get people for weeding operations also. Need not employ machines now. We are a country of 140 crores. Can we afford to ignore the hands which have no work? The problem is this. Let us try to address this problem. Now, this creamy air concept which has been introduced, Justice Gawai must be complimented for recounting the entire struggle of backward classes in his judgment. And then he says that those who have enjoyed the benefits for one generation, give it to the others to enjoy it now. But who will give up? It's not others who will oppose. It is those who are actually having that vested interest. They will oppose this because they will say, no, no, no. I have enclosed here an article by Justice Chandru. Heard of Justice Chandru? Jai Bhim fame Justice Chandru. So please read that also. Take it from ma'am after the class is over. So he says that generations of oppression cannot be done away with one generation of upliftment. True, no doubt. Generations of oppression cannot be done away with one generation of upliftment. Absolutely no doubt. Correct. But then, who suffers? Those who have been deprived even in this generation, even in these 75 years, those who have got nothing. Why does this happen? They say wait for census. After census we have data and then we decide what to do about this. Is it necessary to wait for census? How many of you are from villages? Only 1, 2, 3, 4. Anyone from tribal areas? Yeah, please. Raise your hand. Okay. Yeah, great. Now tell me whether today the government machinery has reached every pada, every village or not. There are 100 social welfare schemes. Now recent is Ladki Bahin. Aadhaar is already there. So we have reached everywhere, no? So we know which is the family which requires help, which is the family which requires educational opportunities. Don't we know that? Can we not do something about this? Or it has to be done on the basis of this fractionization. 10% here, 2% there, etc. Now even in that 10%, after creamy layer is separated, again there will be people who will be deprived. How are you going to define this creamy layer? Is it going to be a dynamic concept or a static concept? Because it has to change every time, no? So today, suppose you have deprived creamy layer of certain reservations and given them to others. They will come in creamy layer sometime, no? So what is the standard which you are fixing for this shift? How do you decide this? This is the practical issue which has not been looked into by the legislators and also ignored by the court. Therefore, whether it is creamy layer or sub-classification, it will have to be done dynamically because today, suppose you remove Minas, because Minas will reduce their percentage and give it to some other classes, or reduce the percentage of Mahars and give it to someone else. What will happen? Those persons will lift themselves up. Then how frequently are you going to carry out this survey and change? Okay. One more aspect. Again, going back to Mr. Jarange. How do we decide what is backwardness? Is it dependent on the extent of property held? In that case, Marathas will be disqualified. Because they are holding vast tracts of land everywhere. At many times they are patels of the village. But does it mean that because simply they have ancestral property which is now worth crores, they have to be deprived of social upliftment, educational upliftment? So these parameters will have to be first fixed. What is backwardness? Please tell me when the time is up. Because this can, in fact, this discussion can go on, and I urge all of you, in your free time, please discuss this amongst yourselves. This is a very important issue. It's good that the judges have given this judgment because it has stirred a hornet's nest. As one advocate Raju More is there, Raju More describes this as hornet's nest. They have stirred the hornet's nest. Now going back to backwardness, what is backwardness? How do we decide that? Some lady from the backside said that she's from tribal area. Would she please identify herself? Tribal area. Which place? Jharkhand. Great. Okay. Please have your seat. So she's from Jharkhand, but she may be from Ranchi. Right? Huh? You are from Ranchi. No. Actually, Birsa Munda's place. Okay. So, how do tribals brush their teeth? With a twig of neem, isn't it? We want that twig of neem to be replaced by a plastic toothbrush and give them toothpaste packed in a plastic container. And that we call development. I'm sorry for using this possibly unparliamentary language, but don't forgive me. You can criticize me to the heart's content. Those who did not even know how to wash their posteriors and use the tissue paper instead are going to teach us what is backwardness and forwardness. Life skills. A tribal knows skills of survival. By giving this education, we are depriving him of the opportunity to study those skills of survival. Farmers, family members who knew farming, who knew bullocks, who knew cattle in their house, now can't. They don't even touch the soil. So they are useless in the field, in farming, and they are useless here because there are no jobs and there can be no jobs. I'm sorry to be pessimistically prophetic, but then there are going to be no jobs in times to come because of too much of dependence on machines. Many of you may be aspiring to join law firms or corporate law houses. With artificial intelligence, your jobs are in danger, and so are the jobs of judges and lawyers. So what are we aiming at? Where are we moving? And what speed? Breakneck speed. Therefore, if we really want that our people who are deprived of the minimum of life, let us ensure that we identify them at the grassroots, not wait for census to do this. See that they get education of survival, education to live meaningfully, education to be independent and not dependent on the government for doles. They should be able to say that, no, Larki Bhain, please, don't give me crutches. I can walk on my own. What are we providing is crutches. Become dependent on us. So that you always, there is a MLA somewhere who said that, see, if you don't vote for me next time, I'll withdraw this. So making you dependent on the whims and fancies of people in power is something not wanted. No? Let us go back to the judgment. So first is, this was a very meaning judgment. Judges did not mean to say redistribute assets of the society. That was not there. They simply upheld some legislations which were passed by the competent legislative assemblies. Okay, but in my view, not competent to pass this. I am with Justice Trivedi that this should not have been tampered with by state legislatures. This will create problems. So, and this needed further discussion. This needs a lot of manthan at every level, not morchas or Bharat Bandhs. This is a question of future of all of us, not just those who have been getting benefits right now. Because see, if the youth of this country is left without jobs, their hands are without work and their brain is without a thought, we will all be sitting at the tip of a volcano. We won't know when it will erupt, and it will engulf all of us. So please, this is an opportunity given by the Supreme Court by laying down this judgment. Let us all think about all aspects of the matter. And rather than any hasty step, somebody suggested, I think Justice Chandru has suggested, that let there be a constitution amendment immediately to nullify this judgment. I don't see why a constitution amendment will be required. It's simple. Aren't those legislatures, those assemblies who have passed these laws, to repeal those laws? Matter is over. Isn't it? Why bother the parliament, and particularly at this stage when parliament should be busy in other business? So therefore, let us put our suggestions, let us put our thoughts across, let us discuss this threadbare at every forum, wherever we get an opportunity, and thrash out a solution which will really ensure emancipation of the person who is at the lowest level of the social ladder. There was one Justice C.S. Dharmadhikari, Chandrasekhar Dharmadhikari, a Gandhian. When we talked of percentages, so he used to say, well, you say, doctor, that only 10% of persons die of this particular disease. But those who die 100%, no? Because 90% live, it does not mean that I have 90% of life in me. I die completely. So therefore, these percentages won't work. We have to work at the ground level to ensure that the quality of life of every person is improved. And that can be done by ensuring wages which are on par with those who write programs. Wages for laborers in the farm should be on par with those who write computer programs. Justice, we ignore many things, but Justice B.R. Gavai recently said about disparity of incomes. Have you read that? So, an opulent wedding we all saw recently. Exorbitant expenditure. It was vulgar display of wealth. And what is the situation here? Even in places like Pune, suppose we were to apply that creamy layer principle or something like that to cities and states. Okay. So, Pune is a forward area. There is no problem. So, don't give anything to Puneites. What about the slum at the bottom of Parvati? What do we give them? What quality they have? Do they get water? Drinking water? About drinking water and sanitation, I reserve my thoughts for the next lecture. Okay. So thank you very much for listening to my vitriol, if I should describe it like that. If you have any questions, I'll be happy not to answer them. What do you Shri Hari? Shri Hari has a question. Shri Hari has a question whether the judgment would pave way for more autonomy of states. Now, We had in the ancient times, before the Britishers came, we had how many states in India? At the time of independence, when British they made all these states independent. How many states or princely states were there? 60. Not these states, princely states.
550.
550. So do we want to go back to that time when there are 550 fractured Indias fighting with each other? You have seen police of one state opening fire against police of another state in this country just a year ago. Where did it happen? Assam Rifles, and they stood with arms against each other. Yes, more autonomy to states as far as welfare measures are concerned is okay. What is happening with CBI and the local police? In West Bengal, the local police files a FIR against the CBI officers. CBI files FIR against the commissioner of police. Governor raising his sword against the Prime Minister, Chief Minister, and Chief Minister giving a gathi blow to the governor. Is this going to bring about the dream of one India? Or you want to say that no, we are not one at all. We are fractured and we want to give us fracture. How are we going to compete with the world with this type of fracture? If we fight amongst ourselves, and that is what the Western world, the developed world wants to do. That is what they did when they partitioned India in 1947. Ensured that we had a continuous fight with Pakistan, draining our resources. Why? Because their armament industry, their aircraft industry should get work. Even now, what is happening in Ukraine or Russia is about breeding them to test our weapons, that is American weapons, to sell their stockpile, which is not being sold because there are no wars anywhere. Therefore, state autonomy is really good, no problem. But to what extent? Now, look at smaller states, how things are getting manipulated there. Look at municipalities and gram panchayats. We have got autonomy now. Article 243, ABCD, EFGH, XYZ. Okay. Local self-governing bodies have been given autonomy. What has happened? How are they functioning? Does anyone care to study? Therefore, I am in favor of autonomy. In fact, what I suggest is that at every level, we should find out what is local requirement. But then, at the cost of the idea of India, no. Sare jahan se acha Hindustan hamara. So, Hindustan has to be preserved first, and then comes everything else. Are you satisfied? Yes, please.
So there is another issue about the sub-categorization of the courts in the city states. That is the Rohini Commission's recommendation. How you see towards this problem?
This has been constitutionally held to be valid. Yes. So again, what happens is this is vote bank politics. Whosoever has larger numbers and leader of whichever community is stronger or has more proximity with the people in power, he gets that done. ABCD, etc. On what basis is this done? So first let us decide, set up some parameters for deciding what is comparative backwardness. Or we are going to do it according to whims of fancy, our own whims. No, that won't do. And therefore, this requires a debate, not in the parliament, because parliament, there is no contempt of parliament, no. So parliament passes laws. This recent BNSS and BNSS, in how many minutes they were passed? Huh?
Without debates.
Yeah, without debates. Therefore, they will pass something, but yet us, because it's a question of your future. It's a question of future of every young man and young woman in India. How are you going to do it? And about backwardness, no. What happens to women in India? Huh? There is a talk of 30% reservation in electoral offices. Has it come about? Or we have sarpanch patis. Wherever this has been done, no, we have got sarpanch patis. पंचायत देखते हो क्या? So these are the things, these are realities of life on which we must focus. Okay. India can't fight with the world with one hand tied. That is, woman, you can't tie her up and then say that we are going to fight with the world. No, you can't do that. So about this, all these quotas, etc., think of individual. Think of how to emancipate, how to uplift that person. Thank you.
So my question is that recognizing the classification, sub-classification in caste is important. The sub-castes of any caste, be it a Savarna caste or a Bahujana caste, they do have a hierarchy. And should one valid takeaway from this judgment also be that the fact that this hierarchy does exist and there needs to be more discussion on this hierarchy? And it has been more or less transferred from the Savarnas to the Bahujanas in a way. And this discrimination for them right now is more visible.
Even today, after
75 years of our constitution, a Dalit groom is not allowed to mount a horse. In very progressive state of Gujarat, this is the reality of life. Her question about hierarchy within the castes. How many types of Brahmins do we have? Brahmins? Any answer? I am taking Brahmins because it is easy to touch Brahmins than anyone else. Huh? Popularly too. What is it? Deshast and Kokanas. What about Saraswat? Are they Brahmins or not? They are. Okay. Heard of Kayasthas? Heard of Maithili Brahmins? Narmadiya Brahmins? Karades? Maharashtra Karades don't consider Kokanasthas to be Brahmins. Okay. So everywhere this hierarchy is there. Everywhere this hierarchy is there. But this hierarchy won't come to an end by how far you are going to take this sub-classification. Do you know that even among Mahars, before Dr. Ambedkar came to unite them, how many subcastes were there in Mahars who did not intermarry? Do we know this? What about annihilation of caste about which Dr. Ambedkar spoke? Where is it? Have you read Annihilation of Caste? No? Yes. So at least read it once. It was a speech for which Dr. Ambedkar was invited to deliver and was not permitted to deliver when he sent the text of the speech. That invitation was withdrawn. Mercifully, Dr. Kanti Deshmukh and Dr. Namita D'Souza, even after I circulated this, did not withdraw the invitation. Thank you.